Download podcasts at BillPressShow.com and listen anytime, anywhere. This is The Bill Press Show.
What do you say? It's 33 minutes after the hour. This is Tuesday, June 18. It is the Full Court Press. We are brought to you today, coming to you live from our nation's capital, and brought to you today by the International Brotherhood of Teamsters, the good men and women of the Teamsters Union, doing great work under President Jim Hoffa, and you can find out about their great work at teamster.org. You'd be surprised at some of the many fields of endeavor that Teamsters are involved in today, representing working families in public, not just driving trucks, I guess is what I want to say, in the airline industry, public employees, and, of course, the trucking industry. The Teamsters doing great work. Check out their website at teamster.org. Well, you won't hear me say this very often, but I'm very nervous introducing our next guest this morning. We have a lot of guests in the studio, but this guest makes me particularly nervous. Elizabeth Wydra is the Chief Counsel for the Constitutional Accountability Center. But I'm nervous because the last time she was in studio, the lights went out. You may remember that.
That's right.
For a whole half hour, we lost power. I'm just, well, you know.
I broke the show when I was on.
You did. I mean, we had to shut down. So
we got the backup generators fired up and ready.
Elizabeth, nice to see you. Actually, nice to be able to see you this time.
Thank you for keeping the lights on.
We couldn't see you the last time because the lights went on. Remember, we got through the next part of the show using
the lights off our iPhones.
On my iPhone. So the Supreme Court, we were told that the last 2 weeks of June we'd be getting the big decisions from the court. They did not disappoint yesterday. Let's start with the one on Arizona. What did they decide, and what's the significance of it?
So this is sort of the other voting case of the term. You know, everyone has been focused on the Voting Rights Act case, Shelby County.
Yes.
But this case is also very important. So the case comes out of Arizona, and as we know, Arizona likes to pass all of these restrictive rules when it comes to citizenship and immigration. And so what Arizona had done was say, okay, we understand that Congress has set a federal form for everyone to use to register, which was intended to streamline the voter registration process, allow more people access to easy registration so that we can really try to include as many people as possible in democratic participation. Seems a worthy goal.
The Motor Voter Act.
Exactly.
Yeah, right.
And so Arizona said, okay, we know that the federal statute says you must use this form, but we don't like that you only have to swear under penalty of perjury that you're a U.S. citizen. We want you to actually attach proof.
Right.
And so what was before the Supreme Court was whether Arizona's additional requirement of proof of citizenship conflicted with the federal law that said, no, you just use this one form, and that form doesn't require you to attach anything to show you're a citizen. You just have to swear under penalty of perjury.
Yeah, right. And the court ruled?
So the court ruled in a major rejection to Arizona's law, written by Justice Scalia, no less, that Arizona's law conflicted with the Federal Motor Voter Act. And when you have a conflict, when the federal government is regulating elections, the federal government trumps state law. And so Arizona's law was struck down.
Right. So you've got not just the four sort of dependent liberal justices or progressive justices, whatever you want to call it, but then you've got Anthony Kennedy and John Roberts, Chief Justice, and Antonin Scalia siding against Arizona.
Absolutely.
A pretty solid rejection.
Absolutely. It's a major rejection. And, you know, Justice Scalia wrote the opinion.
And he's the author of the opinion.
Exactly. And it's a very broad affirmation of the federal government's power under the Constitution to displace state law whenever they act to regulate elections and the process of having elections under the Constitution's grant of authority under the Elections Clause.
And let's point out, so that just also shows, I'll say this, you don't have to say it, how extreme Clarence Thomas and Samuel Alito are in their opinions, that they wouldn't even recognize this case. But What message, is there a broader message than just the state of Arizona here on this decision, do you think?
Well, I like to
Because there were 30-some states that had various forms. Maybe there were 2 others, I think, that had the same thing, doing the same thing Arizona was doing. But there are 30 other states that had various ways, voter ID or shortening the early voting period. I mean, various other ways of trying to make it harder to vote.
Well, so, I think when it comes to those efforts, I think that's another question for the court. This is really about the registration process. So it doesn't necessarily implicate the voter ID requirements that a lot of the states have passed, when you actually show up to the ballot box. So this is sort of the initial entry point into political participation. And so, I think that there are a couple ways of looking at this. I think the optimistic way is that, what Justice Scalia's opinion said for 7 justices on the court is that when the Constitution gives the federal government power, it really means it. There's no sort of unwritten exception for Arizona.
Yeah.
But, the other sort of less optimistic point you can take from the opinion is that Justice Scalia went out of his way to say that Arizona could go back to the federal agency that is charged with deciding what goes in the federal form and ask for a state-specific exemption that says that they can, in addition to the one federal form, require their own citizenship proof.
Yeah, but I mean, why would they do that for Arizona? I mean, what's so special about Arizona that they have to do it differently? I mean, other than the fact that there are a lot of racist in Arizona, as far as I'm concerned.
Well,
I mean,
Louisiana,
they've proven that with the laws they keep passing.
So Louisiana has actually gotten this special permission from the Election Assistance Commission. That's this agency that is charged with fielding these requests. So Louisiana has already gotten special permission in this regard. So it wouldn't be unprecedented for Arizona to be able to come in and say, because we have this citizenship requirement and we feel we need this additional proof, we should be able to require it.
The Supreme Court, 7-2, knocking down Arizona's special requirement, proof of citizenship, when you register to vote. 866-55 press, your comments welcome on that. Now, the justice has also ruled on a Miranda-related issue. Explain that for us.
Yeah, so as everyone who's watched Law and Order
yes,
or movies or knows, the Miranda rulings are you have the right to remain silent, you have the right to an attorney, and so the case yesterday dealt with the right to remain silent part of that, and what the court said was really, I think, a lot of people will find surprising, which is that in order to invoke your right to remain silent, you often have to speak up and claim it. I think a lot of people think, you just remain silent.
Yeah, I mean, I read this, when I read about the case, I really did not understand it. So they said, again, it says, if you remain silent, that can be held against you, used against you, right?
Right. So in this case, the person had not been arrested. So he actually was not required to have his Miranda rights read to him because he hadn't actually been arrested. He came into the police station voluntarily, was being asked questions about these 2 murders that had occurred after a party. And so he was voluntarily answering questions. And then the police asked him, so will the shell casings we found at the site of those murders match the gun that is at your house?
Yeah.
And he didn't respond. And then at his trial, the prosecutor said, oh, but this fellow was answering questions right and left, but when we asked him this one, he stayed silent. And so he's claiming, look, using that against me in court is violating my right to remain silent, which if it's going to have any meaning, if it's going to have any meaning that you don't have to incriminate yourself, then it can't be used against you later. But what the court said yesterday was that, in fact, in situations like that, and in actually, I think, most contexts, you actually have to say, I'm invoking my right. But, most people aren't lawyers.
Right.
Do they have to say the words Fifth Amendment? Do they have to say I invoke my right against self-incrimination? I don't know. And I think that's a
strange case. And this one was 5-4, right?
Yes, it was.
Well, you can see why.
Yes.
Too. All right. Your questions about, and there are some other issues coming up. We'll get into some of those, that other decisions we'll be hearing from the court maybe as early as Thursday of this week. Elizabeth Wydra here from the Constitutional Accountability Center, and our toll-free number, 866-55-PRESS.
Heard around the country and seen on current TV, this is the Bill Press Show.
Here we go, 13 minutes before the top of the hour, the Supreme Court. It always seems like, they hang back and don't do anything all year long, and then just before they're ready to leave for their summer break, boom, 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 we hear about all their decisions. But they've been working on them, to be fair, and having their oral arguments and writing their opinions and thinking these things through. That's what they get paid for, right?
Yes, absolutely.
So we heard what they have to say about Arizona and about Miranda right of silence.
Mm-hmm.
Yet to come, 3 big issues: affirmative action. Any idea when these will come? Affirmative action, voting rights, the Voting Rights Act, and then marriage equality, both Defense of Marriage Act and Proposition 8 in California.
Yeah, so affirmative action, that case was argued in October, and that's the only case that's that sort of old on the court's docket that we haven't gotten an opinion for. But I think it's just not done. I think they're probably going back and forth.
Is this really still at this time?
Yeah.
Do you think, is this the same old affirmative action argument? What's new about this one? I mean, it's a college.
A few new justices on the Supreme Court.
Oh, I got it. Yeah, yeah.
I mean, we had the last cases dealing with Michigan, just about 9-10 years ago. And so, in that opinion, Justice O'Connor said, oh, maybe in 25 years we'll revisit this. Well, I guess time flies when you get 2 new conservative justices on the court.
Michigan said, in the Michigan case, the court said it's okay to consider race as one factor?
Exactly. The court said you can't have these sort of quota systems,
right?
But you can use race as a factor in trying to achieve a diverse student body.
And this particular case says you cannot use it at all. Is that correct? That's the argument?
Well, so it's interesting. So what Abigail Fisher's lawyers argue, she's the one who's challenging the University of Texas's race-sensitive admissions policy. She says that, one University of Texas's policy that takes race as a factor among many either falls under the court's existing jurisprudence that allows you to take race into account to achieve diversity, or if it doesn't, then you've got to overrule those precedents. So, this could go very far in changing the way that schools use affirmative action policies to create diverse student bodies, and as University of Texas has said, to try to create a critical mass of minority students.
I mean, wouldn't it be, even in this day and age, especially in this day and age, I guess, wouldn't it be hard for the court to rule that, particularly in the state of Texas, it would be okay to have an all-white student body in a university? I mean...
Well, the argument is that, so University of Texas has this 10% plan where the top 10% of students in high schools automatically get admitted. And so what Fisher has claimed is that, well, this has already gone a significant distance to create diverse student body. But, I think we get back to this question, which comes up in the Voting Rights Act case, again, is, is it the court's role to really be the one who is setting policy